commission members?
Commission members.
Okay.
Two. Lisa MacDonald and Cynthia Watts.
Mm-hmm.
We're right now in the middle of our confidential investigation stage before we decide whether or not there's probable cause to go forward.
Mm-hmm.
So we'd ask you that you keep it confidential too.
Mm-hmm.
If we find that there's probable cause to believe that either one of them violated the code of ethics that the town has, then we'll issue a written decision and then the record will become public.
Okay.
So, are we on now?
Yes.
Oh, okay.
This is confidential. Why is it being recorded? I don't understand.
Because our record, that at the basis upon which we made a finding of probable cause, would then become public. And we want to make sure that we're getting the story straight, basically, if we're questioned later on. And I also think that we'll be able to use this testimony in a hearing if we go forward with the hearing. But if we don't, then all of this remains confidential. The tape's going to be destroyed. So, but this is also the first time that we've had to go through this procedure. So it's a little bit of a learning experience. We've had other complaints. Excuse me, we've dismissed them in the past. So they were never public. But this one, we're moving forward through this stage anyway. So, I'm Ken MacDonald, and
Bonnie Fillion.
Fine.
John Critchley.
Mm-hmm.
Carol Anderson.
I'm Chris Roybeth.
And you know Mary? No.
I only just met her at the door.
Yeah.
Don't know any of you, actually.
So, thanks for coming. And again, what we want to do is place you under oath. So it's testimony, okay? And so if you would raise your right hand, I'm an attorney and I'll take your oath. Do you swear to tell the truth, swear or affirm, as the case may be, to tell the truth, the whole truth, and nothing but the truth? So help you God, or upon penalty of perjury?
Yes, I do.
All right. And what's your name?
John Main, Chairman, Planning and Zoning Commission. Clinton?
And how long have you been chairman?
At least 2 years now. 2009, I believe. End of 2009.
Are you familiar with the what we'll refer to as the Watts building? And the application?
Quite.
Okay. We're not. We have asked Mary to provide us with the minutes for what we think were two applications. An original application that was denied in
November 2009.
November 2009. And then the second one, which was approved in 2011. And frankly, it's the second one that's the subject of the complaint. And we did read your minutes. We didn't have the entire file, but we read the minutes of that meeting. And I think those issues of recusal were brought up. Is that correct?
Yeah, on occasion.
Yeah, okay. So, tell us, if you would, whatever you can about how it got to the second application before you had mentioned like that. Were you a part of the first one?
Yeah, as a matter of fact.
Right.
All right, how we got to the second application. The original application was denied.
Right.
Did you read the minutes for November 30th, 2009 public hearing transcript?
I think we did, yes.
All right.
What was the first application?
The first application had to do with a site plan and CAM application to develop the Watts property here next to the police station.
Okay.
Straightforward.
Commercial residence?
Commercial.
Commercial.
How many buildings?
Office building. There was a phase 1 with one building, and a phase 2 would have added an additional larger building.
Okay.
John, was this supposed to be a park at one time? Was that the...
That has nothing to do with this application at
It
all. I
didn't?
couldn't answer to that in any way. No.
Okay.
I had no idea.
But it was for
Commission members.
Commission members.
Okay.
Two. Lisa MacDonald and Cynthia Watts.
Mm-hmm.
We're right now in the middle of our confidential investigation stage before we decide whether or not there's probable cause to go forward.
Mm-hmm.
So we'd ask you that you keep it confidential too.
Mm-hmm.
If we find that there's probable cause to believe that either one of them violated the code of ethics that the town has, then we'll issue a written decision and then the record will become public.
Okay.
So, are we on now?
Yes.
Oh, okay.
Yep.
This is
Because I was gonna do that
confidential.
all
Why
over.
is it being recorded? I don't understand.
Because our record, that at the basis upon which we made a finding of probable cause would then become public. And we want to make sure that we're getting the story straight, basically, if we're questioned later on. And I also think that we'll be able to use this testimony in a hearing if we go forward with the hearing. But if we don't, then all of this remains confidential. The tape's going to be destroyed. So, but this is also the first time that we had to go through this procedure. So it's a little bit of a learning experience. We've had other complaints. Excuse me, we've dismissed them in the past.
Mm-hmm.
So they were never public. But this one, we're moving forward through this stage anyway. So I'm Ken MacDonald, and
Bonnie Fillion,
Fine.
John Critchley.
Mm-hmm.
Carol Anderson,
I'm Chris Rowan.
and you know Mary? No?
I only just
We
met her at the door.
yeah.
Don't know any of you, actually.
So, thanks for coming, and again, what we want to do is place you under oath, so it's testimony, okay? And so if you would raise your right hand, I'm an attorney, and I'll take your oath. Do you swear to tell the truth, swear or affirm, as the case may be, to tell the truth, the whole truth, and nothing but the truth? So help you God, or upon penalty of perjury?
Yes, I do.
All right. And what's your name?
John Main, Chairman, Planning and Zoning Commission. Clinton?
And how long have you been chairman?
At least 2 years now. 2009, I believe. The end of 2009.
Are you familiar with the what we'll refer to as the Watts building? And the
Yep,
application?
quite.
Okay. We're not. We have asked Mary to provide us with the minutes for what we think were two applications. An original application that was denied in
November 2009.
November 2009. And then the second one, which was approved in 2011. And frankly, it's the second one that's the subject of the complaint. And we did read your minutes. We didn't have the entire file, but we read the minutes of that meeting. And I think those issues of recusal were brought up. Is that correct?
Yeah, on occasion.
Yeah, okay. So, tell us, if you would, whatever you can about how it got to the second application before the commission like that. Were you a part of the first one?
Yeah, as a matter of fact.
Okay.
All right, how we got to the second application? The original application was denied.
Right.
Did you read the minutes for November 30th, 2009 public hearing transcript?
I think we did, yes.
All right.
What was the first application?
The first application had to do with a site plan and CAM application to develop the Watts property here next to the police station.
Okay.
Straightforward.
Commercial residence?
Commercial.
Commercial.
How many buildings?
Office building. There was a phase 1 with one building, and a phase 2 would have added an additional larger building.
Okay.
John, was this supposed to be a park at one time? Was that the...
That has nothing to do with this application at
It
all. I
didn't?
couldn't answer to that in any way.
Okay.
No.
Okay.
I have no idea.
But it was for
very simple in the fact that I could just say that I had sought Attorney Royston's advisal on the matter for recusal. And his letter to me was dated September 12, 2011. Dear John, this letter is in response to a request through staff that I provide some guidance with respect to the conduct of a meeting where there is a potential issue of whether a commission member should disqualify himself or herself under the provisions of Connecticut General Statutes 811, which provides that no member of a zoning commission shall participate in the hearing or decision of the board or commission which he is a member upon any matter in which he is directly or indirectly interested in a personal or financial sense. He cites the Connecticut Supreme Court case where Thorne and Zoning Commission of the Town of Old Saybrook, 1979. This case stands for two basic propositions relevant here. First, the relationship of brother or sister constitutes an interest in a personal sense. Second, the participation of a disqualified person can render the action of the commission a nullity should we be taken to court after making a decision and somebody would like to file a complaint that with the court system of the state of Connecticut that we acted, against that ruling. And he advised the commission in the past that he found no statutory or case law provision which would authorize a commission chairman or the commission itself to disqualify a commission member from participation if that member declines to do so. So the act of disqualification is solely the responsibility of the elected official. Mm-hmm. All right, so I further go on. He's basically says, I consider it appropriate for you as chairman to do the following in respect to this application. When this matter comes up on the agenda, you are to inquire, is there any member of the commission who may have a direct or indirect interest in this matter, personal financial sense, and if so, would you identify yourself for the record so that I may conduct the proceedings on this matter without your participation? Again, I was advised I could not disqualify anybody, so it's up to them to determine whether or not they would like to do so in the interest of the town, legally. Later he goes on that if any member of the commission believes the commission members should disqualify themselves, please identify the reasons for the record. This is all in the December's meeting, the one that eventually led to the approval of the revisitation of that applicant. And this entire letter was followed during the course of that meeting to basically advise the members of their discrepancies. And all those members were allowed the opportunity to either disqualify themselves or not based on that. Now, in addition, I would like to add that you should have the minutes from August 8th, 2011, amended minutes. Where Lisa MacDonald herself called the meeting in order at 7:35 p.m.
Yes.
Philip Sengel was seated for myself. I was late to that meeting. MacDonald stated that the reason she previously recused herself on matters regarding 186 East Main Street no longer exist, and that it had been confirmed by the commission's attorney, she's referring to Attorney Royston, where she asked the direct question, should I or must I recuse myself where my husband no longer has any financial interests after acting as an architect, being paid for his duties, and subsequently a year or more had passed since she held any financial responsibilities to that project in any way? And his answer was no. That's directly from our attorney.
That was in an executive session?
Yes.
So why was that brought up in executive session?
That was brought up in an executive session because, again, and during that executive session, there was commentary from two other commission members that they felt that there was a conflict of interest. And again, it was against Cynthia Watts and Lisa MacDonald. And while the attorney was present, those questions were asked, which also prompted that letter that Mr. Royston sent to me.
Okay.
Specifically.
Is that why you sought the guidance or the...
Absolutely. Absolutely. I'm caught between a rock and a hard place. I can't say that the people of Clinton, I, John Main, as chair, direct that this representative of the people duly elected cannot serve. I
Well,
can't do that. I have no
that's good.
power to do that, which is actually quite good. Although currently our bylaws don't actually say that. But that's to be addressed at a later date.
Yeah.
However, where the applicant had filed or not filed properly or whatever, all I can say is very simply that it was brought up in the meeting, I believe it was regular meeting July 11th, 2011. Item 3, discussion, 186 East Main Street, John D. Watts. John D. Watts and Planning and Zoning Counsel David Royston explained that the attorneys are seeking direction on resolving ongoing litigation. See, we were being sued by the applicant for failure to dispose of our duties correctly. And our counsel had advised us that we had the potential to alleviate expenditures to the town by continuing with this lawsuit. And we had a motion pending before the court to extend the mediation process, and we could table it. And then later in executive session, we discussed how we could resolve being sued by the applicant in an amicable manner for everybody involved.
Can I just interrupt you there, because that's where we're a little confused. The next application has not even been filed yet. This is what we got from Lisa MacDonald's response to us. She said, you had that meeting on July 11th, and then 10 days later, Mr. Watts files we'll call it the second application.
Site plan application, yeah.
Which then gets approved at that meeting where the discussion of conflict of interest arose. So I guess what I'm asking is what was the litigation about, and how did that arise? Since
the litigation was about, if for history's sake, litigation was about the fact that the applicant happened to have a deal with the selectman's office at acquiring properties, a land swap, where he swapped a triangular shaped piece of land to the, I believe, the east of his existing property that he owned for a triangular piece of property to the west, which overlapped the entrance to the police station on the auxiliary entrance side. In writing the land swap deed for that, it was written in a manner that allowed the owner of the property to retain the right of passway through that driveway to enter his property, which is in accordance with the town plan of conservation and development, where we don't want to add curb cuts on Route 1. It's already very congested. Part of the way to resolve that is to not have too many curb cuts. Technically, not a bad idea. And that resulted in...
So, but at that point in time, the building's already built.
No. This is an empty lot.
Oh no, when the land
When that
swap
land
was
swap
going-
happened, it's an empty lot.
I'm talking about the litigation. How does he get from a denial?
He got
to
from a
building
denial
building?
on the advice of our attorney in the July 11th meeting, 2011, after being sued for a year.
Okay,
Our attorney said to our commission, we can resolve this litigation by means of allowing the applicant to not fully go and reapply, but simply answer the issues of denial of the original application. And that you'll find in the back of the minutes on July 11th. Let's see. Mr. Rossi moved to accept an amended application to address the 4 reasons for denial concerning 186 East Main Street, owned by John D. Watts. Guerrera seconded the motion. There was some discussion. P&Z counsel Royston mentioned that the original application should be a part of the new application. He made that recommendation in case there were changes to the zoning regs where we wanted certain information updated on the plan just to protect the town. Rossi added that to the motion and to include the original application in its entirety as part of the amended application. We made sure that we would not allow fees. There would be no fees, no further public hearing, no further CAM application as it was already approved. See, his site plan was not approved. His CAM application was approved on the original time that it was denied the first time.
What does CAM stand for?
Coastal Area Management. It's required. And there shall be no further referral to the Design Review Board. So ultimately, the revisitation of the application only pertained to the reasons for denial. It was not a full re-app for the same project. It was simply a means that our attorney had allowed us to present to the person suing the town as a means to resolve litigation and move forward.
So, but now the building's built, right? How does it
That
get
building is
built?
not built under that site plan.
That's what we're
That's
confused
allowed
about. We
under
don't
the
know how.
regulations where he can have a home office business and build a home
So is
because
that
it was
what-
zoned residential.
So is that? So
He
that,
can have that home built without a site plan
Okay.
and perfectly legal.
So, just
There's
so,
absolutely no reason he could not do that. Anybody who owned that property could have done that.
okay. So he makes the application for commercial development. That's denied. He then doesn't have to go in front of your board because he says, I'm building a home, a residence.
Home office.
Okay. And so what's the process for that? And then how did you get involved in litigation over that?
There was no litigation over that.
Well, then how's the litigation start? That you're talking about settled?
The litigation was from the denial of the original site
commercial
plan
piece.
for the use as an office.
Oh, so he appealed back in '09, he appealed that decision?
He sued us with the state of Connecticut.
Okay.
And we were under a lawsuit and still pending right up until, I don't know, I think we might have settled this month. I don't know. I haven't been in touch with Mr. Roisman. That all that is settled legally.
Okay. So there was nothing in between that your commission did that led to the litigation. It was the initial denial.
Well, that's kind of a gray area.
Okay.
What we did or did not do, according to the complaint filed by the property owner, we didn't follow the rules set forth by the state of Connecticut in the way we've made our decision.
Okay.
And he has every legal right to make that complaint with the
Sure.
state. Yeah.
Sure. Okay. But that's what I think we were unclear about, how it gets denied, but something gets built anyway.
Yeah, because it wasn't built. It was built under a different set of the regulations, and he followed everything to the letter of the law.
Was it built in accordance with the same application, the site plan? Is
Can't be.
everything
No,
exactly the
totally
same?
different. He doesn't need a site plan. You can build a house, home office on there without any discussion by the zoning.
I guess the
commission at all.
answer to my question, though, is it must be obvious, though, because now I'm thinking of what you said, which was he came back with an amended application.
No. You're saying he came back with.
Yeah.
We were in litigation
Right.
during a lawsuit against the town.
Yeah.
Our attorney devised the means for us to resolve that litigation without having to continue for a number of years, where we would lose the right as the Planning and Zoning Commission. We would lose our rights where the state then dictates to us what's allowed and what's not allowed. How so that happens is when a judge says, Clinton Planning and Zoning Commission, you did not follow your own regulations or you violated the law in your decision process, he then has the right as the judge to to decide what is allowed and not allowed on that property, regardless of our regs.
Well, we could-
And he has leeway to do that. You could argue with anybody on that. That's fine. We could talk until the cows come home. It isn't going to make any difference. I've seen it happen. So basically, we decided as a commission, and it was voted on right here in these minutes, everybody voted in favor to let the applicant go through a process recommended by our attorney to remove our problems with this litigation and resolve the issue.
Okay. And everybody voted on that, including, that's probably...
Oh yeah, it says, in favor, Rossi, MacDonald, Guerrera, Sengel, Dalia, Watts, Irmischer.
Okay.
The only person opposed was Mr. Krebs,
Okay.
and I didn't vote as chair.
Right. Okay. Anybody else have any?
Well,
Go ahead, Mike.
I guess my biggest question is that you do have members seated, I mean, not seated, that they could have, so why would they not recuse themselves if there's other members that could be seated in their place and make that vote? Why would they?
If we're having a vote, if I'm in the middle of a vote and a motion is on the floor, and they did not recuse themselves, I don't see anybody in their place. We vote with the membership that's there as part of the quorum. If you recuse yourself, you leave the room or you step aside, and you and I will make the decision. You just lost your ability to vote at all or represent the town that elected you.
Yeah.
So
It's that simple.
I think Bonnie's question is, these two women did recuse themselves from the first application. What changed, as far as you know, if you know?
What
If you don't
changed?
know, yeah.
For one thing, what changed was there was no longer a financial reason for Ms. MacDonald
And
to recuse herself.
How do you know that?
She asked the attorney directly and stated that she had been paid.
Okay.
She stated before our attorney and the entire commission,
Yeah, that's
I have been paid.
Right. Okay.
Or not I, excuse me.
Her husband.
Indirectly, her husband
Right.
is no longer a part of this project.
And there was no decisions that the commission could have made that would have caused him to revise his plans at that point, or revise the drawings?
I don't understand what the
The
question.
husband, he was the engineer, he was the architect.
He's the architect. He drew the picture. He put it on the prints. That's it. He's done. He gets
Made a
paid. He's done.
presentation to the
Well,
planning
she
and
said he
zoning.
was a project manager.
No, he's done. He
Well,
made
she
no other
said that.
He
presentations.
came to one of your meetings and presented the whole
Right.
project.
That was back in 2009.
Yeah.
That was denied. That application was denied.
But then
It
you're.
was the same application.
But actually, it's the same application you're telling us.
Oh, yes, the same application was brought back as a resolution to a lawsuit against us, only to determine if the reasons for denial were met, whereby we might approve said application. In other words, it wasn't a full application process. What changed was there was nobody coming before the design review. There was no interest where, this person who was the former project manager was before us. He was no longer involved. The parties involved, Lisa MacDonald specifically, asked our attorney for legal advice. Where do I stand? And our attorney, who we rely on for all our legal issues, told her, you do not have to recuse yourself.
Any idea why she wouldn't anyway? Just for,
I'm sorry, but if I had no financial reason according to your ethics code, why wouldn't I sit in an elected position where I'm
You
allowed?
challenged her.
Yeah.
I'm sorry?
You challenged her. You
I
came to
challenged
that
her
meeting.
when?
You had no. This is what was of interest to me particularly was that you had I don't know the dates, but you had sought
November 14th.
you had sought
November 14th.
Attorney Royston's opinion on whether you could
Yeah.
remove someone from
Disqualify.
the disqualify.
I was asked by other commission members that these people should be. I have to ask my attorney.
Oh no.
Yeah.
Just so you must have known this was going to be an issue.
Oh yeah,
Or-
it was
or
going to be
gonna
an
be
issue.
an issue.
Any chairman would say, yeah, I would have known that was going to be an issue. Yeah.
Yeah. And so the minutes you read just that. Another person, Fritz, read the state statute for the zoning, which is even a little more broad. And so we were just wondering if the chairman and someone else had, I use the word challenged, and that might not have been the right word, but asked them to think this through and recuse themselves why they wouldn't.
I can't answer for them why they wouldn't. I don't understand why you keep repeating that question. I don't know how you're expecting to answer that. That's kind of a vague way to ask why. If you want a personal opinion, why I don't think they should have recused themselves or should have.
Do you think they should have?
I would say that if it was a full application, yes. That they followed the regulations fully during deliberations about what our attorney was advising us, how to relieve ourselves of a lawsuit. I don't think that it was inadvisable that they spoke their mind at that time. They kept it to the regulations, except for where they were personally attacked in meetings, of which I was there for every one of them. They were personally attacked each time, and in each time they answered that personal attack. That personal attack was, you shouldn't sit here, you have no right, you should recuse yourself, and that Lisa answered, look, I am not financially being compensated for anything with this application anymore. She asked the attorney. These same people that you referred to, Pamela Fritz and Selma D'Elia, they specifically stayed on their haunches about it and kept piping up about it, and that's fine. I allowed them absolute for public record and during executive session. Absolute, they can ask what they want and say what they want. That's fine. It was
so above board. I mean, it was so, that we're just, sitting here. You have certainly put the second proposal in perspective for us.
Yeah, which is good.
Which I'm not sure we've strung it along quite that way. One of our questions was, how did Lisa not know that there could have been some decision made during the second meeting that would have caused the drawings to be redrawn or the house to be re-engineered or something?
None of that was allowed. The only thing that was allowed, we accepted the application the way it was. It sits over here in the minutes.
So it's really just...
For the second or third time, I'm going to tell you. You have the minutes right here. Nothing is to be changed except for the reasons for denial. If this applicant addresses the reasons for denial sufficiently, we may remove the problem of this litigation by approving it, which is why we were being sued in the first place. So, every commission member there, every one of them, there's no record here that says anybody stood up on that minute right there and said, these people need to recuse themselves or be in our minutes. It's not there. They did mention, mostly the night, December, when we were moving to approve this, and during executive session, of which I'm not going to go into in particular. It's not recorded. I can't quote it about July or June. But I would say, yeah, everybody was aware that there was a potential for a problem, and that potential really is in regard to whether or not we would be sued further because somebody didn't recuse themselves and approved a said application. And again, going to the vote in December as to whether or not to approve the amended application as described in these minutes, on that night, I could have, as chair, which I did state, according to the letter from the attorney, I polled this commission. I asked for people to recuse themselves. They chose not to. I cannot, once the motion was on the floor, arbitrarily say, okay, I'm making you disqualified and I'm seating this person over here, so I could not do that. And then in the end result, the only thing that's disappointing is that, well, perhaps Cindy could have recused herself because she's directly related to the applicant. However, considering the 2 years of legal discussion, original denial, and problems involved, I believe she was acting for a sense of justice for her constituency as opposed to trying to approve an application strictly for her brother. And only because if you read the minutes from even 2009, there's an entire case of minutes. Do you have these?
I think so.
The written minutes?
Last one.
We have too much, that's the problem.
Oh, I understand. But in that transcript of 2009, where they did in fact recuse themselves, both the parties, because it was a full application before us,
Right.
not just
Well, it's a full application. It's
not just the reasons for denial. That's the point of bringing it up with the attorney. He brought it back only to address the reasons for denial to alleviate litigation. So we weren't trying to address the entire application over. In this transcript specifically, I am asking repeatedly that people such as Mr. D'Elia, Ms. Adler, and Vincent Semino. They basically go on and on in this application, or in this process. I believe it was a public hearing. Yeah, public hearing November 30th, 2009. Those parties go on and on and on and on about whether or not the land swap should have happened, whether or not the selectmen should have told us how the deed was written during the land swap, all of which I repeatedly say in these minutes, we have no legal jurisdiction about a land swap. As the Planning and Zoning Commission, we can only look at our regulations and either affirm or deny the application based on the regulations, period. Our own town planner later advised us we have no right to talk about the entryway to the police station. Legally, that falls under the Department of Transportation. Our own legal counsel agreed with him and told us that. These parties, D'Elia and Semino and Adler, have been opposed to this for those reasons since 2009 and have continued to be that way as far as I know.
So was there were alternates though, right? I mean, you have a full commission plus alternates, right? So there were alternates who could have heard the amended or.
I think what you're trying to ask is, had they recused themselves, somebody would have been able to have been seated in their place?
Yeah.
Yeah, of course.
Okay. And can you tell us, would it have passed? Because you seem to be saying these three people who voted against it or whatever, and then the first time and they do it the second time.
You mean could it have been denied? It was passed. You mean could it have been denied?
Yes.
That's the other way to ask.
Yeah.
Well,
All right. Considering the fact that, could it have been denied if anybody on that commission decided to vote otherwise? Of course.
Right. Okay.
Yeah.
Did it have to be a unanimous decision?
No.
no.
Majority vote.
It was one poses.
But again, during the proceedings, all the alternates
Only two.
that are privy to all the meetings that attend and or listen to the minutes are eligible to vote if they're seated at any time during the proceedings.
Right. No, I understand.
In other words, right up until the night of that decision process in December for this particular application, there most certainly, if any one of these people that you're looking at, Lisa or Cindy, if they recuse themselves, I'm certain there would have been a qualified candidate to sit for them. However, that they didn't recuse themselves, I wouldn't have seated anybody for them. In other words, at the beginning of the meeting,
do anything.
At the beginning of the meeting, if I don't have a quorum, I seat an alternate. Once the meeting started, that's when somebody recuses themselves. So it's an irrelevant question to say, would it pass or not pass had somebody else been seated? I wouldn't have sat anybody else in their place, because at the beginning of the meeting is when you seat alternates. You don't seat them in the middle.
But he's on the agenda.
Of course.
Okay, so
Of
they
course.
could have
Beginning of
recused
the
themselves at the beginning because they saw, like,
So,
they did
so
on
let
the
me
other-
ask you, in the beginning of the meeting, I ask who's here, we have a quorum. When the item comes up on the agenda, if it's item 2 or 1 or whatever, first I have my point of discussion, then I have my ZEO report, then I get to item 1. Now item 1 is the application. Does anybody want to recuse themselves?
Right. You,
Yes or no? They still have the option to recuse.
but you don't have the option at that point of seating somebody?
No.
Okay.
That's what I've said 3 times now. I see at the beginning of the meeting. Once somebody
I'm a little
recuses,
slow, so you have to-
once somebody recuses themselves during the meeting process, we do not selectively add an alternate in their place.
Okay.
That never happens.
Okay.
Never.
So the seating has to take place at the beginning. of the
Seating
meeting.
takes place at the beginning of the
And
meeting.
that's what happened in the first application.
Yeah. You'll know nobody was seated. It would have been part of the minutes that if somebody was to, if we ever did that, they would have been seated in 2009 in place of the 2 people that recused themselves. That did not occur. The people who voted were the remaining commission members
Right.
there to vote.
Okay.
Well, based upon what you said, I totally agree with you. There's nothing that you could have done. You could have asked people to recuse. If they didn't do so, that's really on their conscience. To me, I'm just a layperson in all of this, and I'm trying to get my mind around an application, a reapplication, an amended application, a pseudo-application, and a non-application. This is the same property, the same project, owned by John Watts, project manager Michael MacDonald. And there are 2 people on this commission who had ties to both of them. And Lisa MacDonald is the wife of Michael, financially benefited from the project and continues to do so. I mean, the money
How
is
does
somewhere.
he continue
The
to
money
do
is
so?
somewhere, right?
If you hire me to wire your house or draw a picture for you and you paid me, once you paid me, I'm no longer financially tied to you in any way. You paid me. I'm done.
Yeah, but at the same time, she financially benefited from her husband's work.
But what you're
It's
saying,
very project
what you're
oriented.
saying
It's
is,
very project
what you're
oriented.
saying though is the decision process. That her
No, I'm
decision.
saying
Hold
what
on.
the outcome
The
is.
decision process of the commission is based on our regulations. What you're saying is that she benefited by voting yes or no. She didn't. Her husband was already paid a year before, over a year before. It was 2009 when we denied the application. His financial ties were over, and according to legal counsel, she was told she did not have to disqualify herself or
Well, that's his
recuse.
opinion.
He's our attorney.
I know, that's his
Ugh.
opinion.
You gotta listen.
I'm sorry, but that's our attorney. Telling a commission member who had concerns a direct answer on the record in front of the entire commission. I wouldn't say it was an opinion.
It is a
That's
legal
our
opinion.
attorney.
Yeah, it is.
Would you know why she had a concern to even ask?
Because other people complained. She was
Oh, that's
answering
true.
a
I didn't
complaint.
realize that.
She was trying to play ball fairly the entire time.
Interesting. Very interesting.
I lost it because I was looking for the,
There's more of a history with this property beyond this, if you're willing to ask. I'll be happy to divulge more.
I asked you that before,
No, I'm talking about
but I asked you.
the people that complained in the 2009 meeting, Mr. Semino
When I
specifically.
had asked you, you said that was not relevant.
No, I had said that the actual full application wasn't relevant at the beginning of this meeting, but you said you just wanted to clarify history. And I've agreed with my testimony the entire time, now that you clarified that at the beginning of the meeting. Now, where it concerns Mr. Semino, Mr. D'Elia, Cynthia Watts, John Watts, and the town, Mr. Semino was the RTC chairman. Mr. D'Elia is a member of the RTC. Mr. Semino attends every meeting. He was a primary agitator against this application the entire time. He was voiced his opinion continually in Harbor News concerning that property. He actually made a number of complaints along with a Ms. Adler with our ZEO, which is all part of the public documentation in our files. He also sued the town because the property kitty corner to that property he lost because he didn't want to follow his approval, which required him to take the little house in front, restore it because it was built in the 1800s. And the commission at the time said it was a historical property and that he should restore it. So there's a full history of animosity that was directed through a portion of the commission at other members, and I've had to sit through it for 2 years. And I tried to remain as impartial as I could the entire time. I did ask certain commission members if they had a problem with things, if they were related to people, that they should consider recusal. Lisa MacDonald, at least, I believe, absolutely addressed her concerns with our council before the commission. Cynthia Watts, knowing that this was going on for 2 years, I mean, it's absolutely evident, specifically felt, I certainly believe she felt, she didn't feel that she needed to recuse herself because it wasn't a full app, and in the interest of the town and the litigation, wanted to have a voice of reason during the proceedings.
It didn't have anything to do with her being the sister of John Watts.
No. Not that I could determine. And I have to sit with these people. I've sat with them, at least once a month or more for 2 years concerning this act.
So, could the alternates have been a voice of reason? That's what we're trying to get at. Like you make it sound like
I have to have the person involved has to voluntarily recuse.
I'm not.
Could anybody have been a voice of reason? Yes.
Okay.
Absolutely.
So that's.
It's kind of a moot point. I understand why you ask, but honestly, yeah, of course the answer is yes.
But what sounds odd to us is when you say the voice of reason, it's as though if she didn't vote, then maybe it wouldn't have been approved because some other
I disagree, because if according to the way I've explained how the procedures work, if she recused herself and Lisa recused herself, it still would have approved according to the vote because I wouldn't have seated anybody in their place.
Unless they recuse themselves at the beginning of the meeting.
No, at the beginning of the meeting I open up, we say who's there, we have a quorum. Nobody's asked to recuse themselves unless they volunteer to do it at the moment the item is brought up.
Correct.
So I would not have seated anybody else. It would not have happened.
They would have had to take the initiative and not show
exactly.
up.
And after, from July until December, I think that if anybody was inclined to take the initiative, the first time, according to the record, that it was brought up, that we asked our attorney's advice, that he had time to deliberate and respond to my inquiry, months had passed. Months.
There was you may not know the answer to this, but there was another person who abstained from the vote. Krebitz. And he had voted against it the first time around. Any idea why he abstained?
You have to ask Alan.
Okay.
I don't know why somebody who would, if you read the minutes, who would so adamantly oppose something,
right,
when they had the ability to actually deny, abstain. It makes no sense to me. I think you would probably want to ask Alan that. I didn't personally ask him.
Because that would have, if he had voted, and if he voted no, then it would not have passed, if those two.
Absolutely true. Right. But again, you'd have to ask Alan why he felt it necessary to not actually, personally, if I was so adamant about something, I probably would vote against it.
But again,
according
if he
to my
knew they were going to vote in favor and the vote was already going to happen.
Don't know.
Yeah.
Don't know. As a matter of fact, Alan sided with Mr. DeLea and Mrs. Fritz on a number of occasions, as the record shows.
Right. Okay.
Many times.
Okay.
And still, I don't know. I couldn't tell you.
Okay. Is there anything else you would like to tell us about the history of this? Just to help us?
I would actually rather ask you guys do have any more questions, because I don't know what else you might be looking for other than the relationship between Semino, Adler, D'Elia, Fritz, and their campaign. Very apparent campaign to deny this application a second time.
Okay.
It's very evident.
Okay.
However, contrary to the minutes, they actually participated in allowing the litigation, the opportunity for the litigation to end by saying they approve
Of him coming
looking
back.
at the app only for the reasons of denial, as spelled out
Right.
by our attorney, and the way we all approved it, especially through a very heated discussion in an executive session,
Right.
which was very unfriendly.
Hmm.
But they got through it. They worked through it. And I personally feel that the application was approved on the basis of the regulations, the way it should have been, and intended the first time it came before us, and was not approved. Personally, I think we saved our town a lot of effort of legal problems, and ones we couldn't defend, that eventually would have been disproven in a court of law in the state of Connecticut, easily. Which is why our attorney kind of advised us, hey guys, maybe we can find a different way to address this problem. And I think he did it wisely. And, of course, a 5-member commission approved it, all of whom are the people that were having this unfortunate infighting going on.
Right. Yeah.
Yeah?
I have another question, just one more question. There was a motion after this one.
What do you look
For
at?
something, let's see, November 14th, after it was approved.
This year?
In 2011, it was on Liberty Street. And Rob Duano voted on that. He didn't vote on this, but then he voted on the next thing. So how was he seated to vote on that? It was,
I don't know, what minutes do you have?
I have the minutes of November 14th. He was not seated. And then,
And now he's voting in favor of the very next item.
yeah,
Yeah, how's that happen?
Yeah.
November 14th. The last page. Okay, let's see.
Which name?
Rapiano. Yeah, because Rapiano voted against.
You're saying item 5 he voted for?
Right after the motion for that.
Because he
one.
actually, no, in favor. MacDonald, Watts, Guerrero, Emershall,
Like,
Rossi, in
right.
opposition, not voting. Brown, not seated.
And then the next one,
But,
it's the same meeting. Is
I
that?
have
is
no
it- oh, it's-
idea.
Liberty Street,
Okay.
Gordon, Kellen Gordon.
Yeah.
Gordon.
And I'm not looking at it anymore, but I'm just wondering, okay, McDonald's there, he wants to, yeah.
I have no idea what the minutes reflect that. Because he wasn't seated. I wonder if that's a typo. MacDonald, Watts,
Oh, yeah. Okay.
Guerrera,
I
Fritz.
saw it a couple times when I was going through, did you? Because I was trying to figure out when you're seated and when you're not. And I was seeing people being seated on one vote and then
Not
not
seated on
seated on the
the
next, and somebody else would step in, so I was, yeah.
The only time that usually occurs is if
That happened through the next one? after
if
Yeah.
that, too?
if
And the one after that? So all of the ones after his votes on, according to the minutes. And that's why we were confused.
I'd have to ask about that.
Yeah,
The
every
single
single one
wasn't seated.
afterwards.
Rappiano's not seated. No. All right. If somebody is absent from the meeting, enters the meeting after it starts, I unseat an alternate, and they are seated as a standing elected member of the commission.
So did somebody leave?
If they, in other words, you want a quorum of 5.
Did somebody?
Yeah, somebody
Leave.
must have left at that point. and he was seated in their place. But that's not in the middle of a motion. In other words, that's prior to having the item brought up to the agenda.
Okay,
I know
so,
what
Rossi left at 8:42 p.m.
Yeah.
Yeah, but then 8 people voted on the next vote, so.
So yes, we can seat people
6, 7, 8.
okay.
in between items as they're leaving.
Okay.
Okay.
So do you want to
Where?
change what you said?
No, because when the motion's up, if nobody's recused themselves,
No, I understand, but when you got to that agenda item,
what I
could've-
what I meant to say is that once we've started the process, as people come and go, yes, they are seated, but during recusal, we do not seat alternates. Is what I am meaning when I say that. When somebody recuses themselves and there's something before us, I don't seat anybody. If during a meeting, in between items, somebody says, I have to leave,
like because I'm going to recuse myself.
no, I have to leave.
In the first time.
No, you don't understand. Once the item is brought up to the attention of the commission, we are now on item 3. When somebody recuses themselves because I have something going on with item 3, they are not, the alternate is then not seated for that person. We don't seat an alternate because they recuse themselves. We only seat an alternate if we have less than 5 members during the discussions or deliberations portion before we go to a motion or get involved in it.
Is that written somewhere?
No, you'd have to ask Julia Pudum for that specifically.
Because what we saw earlier was that Cindy Watts didn't come, so that would allow someone else to vote, I guess, and then.
We would have seated somebody in
then
place
Lisa
of
MacDonald also recused
Cindy,
herself
or
right at the
we would have
beginning
seated
and
somebody
left.
in place of somebody else, yes.
Yeah.
However, still, once we started deliberations and somebody made a motion, if they did not recuse themselves, we don't seat anybody else. We simply say, you've recused yourself. We also review who is eligible or now eligible to vote. If we have 5 members on the commission and one of them did not attend or listen to the tapes for a specific public hearing, they aren't allowed to vote because they aren't able to display that they have knowledge enough to make a decision yet. So that's why we require our membership to listen to audio recordings of the meetings. Yeah.
Is this a standard part of your procedure before every item comes up as chairman, or is it brought up by zoning enforcement, whoever? Does there anyone have an issue with this? Does anyone want to recuse themselves? Is that something that's a standard procedure?
It is normally accepted understanding as a planning and zoning member that if you have a relationship.
So it really is upon the member itself.
I've recused myself in the past because I felt there might have been a problem with the fact that, let's see, I'm on Brickyard Road. The property across from mine was going through a subdivision process. I recused myself. Why? As a member, I was told by the chairman at the time that we recuse ourselves if there's any need to, where you think there might be a shadow of a problem. And the reason we do that is so that nobody can sue us in town later under the idea that something was approved that should not have been allowed.
Well, it looks.
So it's to protect the town from litigation. That's why we recuse ourselves.
Well, to look right too.
Of course.
Interest.
I completely agree. I've recused myself simply because the guy lived across the street,
Right.
Mr. Schumack, knew him forever.
Right.
Not personally,
Right.
but he did come before the commission before, but never about the property across the street from my house.
Right.
Now, I didn't have to recuse myself. Technically, there was no financial dealings, ethically or morally, for me to even worry about his property across the street. However, Somebody could have sued, he could have sued us if, for some reason, somebody denied the application. They could have said, well, John Main didn't recuse himself. He voted against. If I voted for his application, he wouldn't sue. If I voted for his application and it passed or didn't pass because other people believed that it didn't meet the regs, then he couldn't sue on the grounds that I didn't recuse myself because I voted for his application. So it's really, it's a very gray area in the sense that, as long as there's no direct financial or personal relationship, yeah, okay, it's kind of a gray area, and for the benefit of the town, I recuse myself. That's my option as an elected person.
That's it. Now you're drawing a distinction between an active application, as what you just described, and this procedure for alleviating the lawsuit. Those are two separate entities within the planning and zoning realm.
No, it's not. It's not written that way. What it is simply is that because the means to alleviate a lawsuit through the attorney regarded only the issues, and only the issues for denial. Did the applicant meet the issues of denial sufficient for the commission to change its mind about its original decision and therefore approve the application from 2009 as it met the reasons for denial? There were 4 reasons for denial there in the minutes. Had to do with parking, the entryway off and off route, on and off Route 1,
and the use of that road.
The use of the road, which we have no legal grounds as a commission, which is why we allowed that. Of course, we had to allow that. That was part of the reasons for denial. So there were 4 reasons for denial. So it wasn't like this was an entirely new application nobody ever saw before, and it was more like, okay, look, we're under litigation. Our purpose for allowing this to come through is specifically to address those issues and alleviate litigation, not to readdress the entire application.
Can I stop you there, because we're running out of little time here. Phase 2, is that part of this application? I haven't looked at the maps and all of that. But is Phase 2 approved as well, or does he have to come back? No. Okay. So,
not that I'm aware of.
Okay.
I'm pretty certain the entire thing's approved now.
Okay, so when that's built, do you know who the project manager would be?
No. Now that's understanding that he can only build what was approved. In other words,
and so, but Phase 2 is approved now, so he can build another building according to planning. This application is
the entire application, the way it was presented in 2009,
has now been approved.
It's been approved.
2011, based on that vote of November 30th of 2011. And you don't know who the project manager will be. Okay.
Yeah. No.
Okay. And that, okay. Anybody?
No, I think
Very interesting.
Yeah, it's a convoluted tale. It really is. It's very sad that I got this far.
Yeah, and we appreciate you coming here. And none of us were questioning. We saw you as the voice of reason, frankly, when we were reading minutes, and thought you would be the guy to come here and kind of give us an unbiased.
We have no influence over the decisions at all. It's just some of the participants and the order, refusing, not recusing, saying yes, saying no, being challenged.
No, I completely understand that. I would say that there's at least a number of members that still aren't up to speed. Once you have new people on, it can take a couple of years before they figure things out, if they bother to pay attention at all. And it's not easy.
So he was already suing. So if you denied the
amended application,
if you denied the the 4 points of denial.
If we gave the thumbs down, the lawsuit stood, and we just continue litigation and eventually
To a point where
see
he could sue because he would sue because his sister and his project manager's wife was on the board.
No, we were already in our lawsuit.
Yeah, that's what I mean.
Thank you very much for coming in.
The last thing, though, was a letter from the attorney, which was...
Do you want to give us any of those, or would you mind giving us copies?
License letter?
Yeah, I could get new copies, I guess. The last letter you should have, though, was as a supplement to the December 6, 2011. Please be advised, no appeal was taken of the John D. Watts decision for East Main Street for modification of site plan. The appeal period had lapsed, so nobody appealed. So nobody else continued to sue in any means or way against us for recusal or not recusal. There was no justification for, I mean, they had a time period where they could sue or appeal. None of that was done. Do you have that letter?
No. I don't know. Do we? Is it in here?
In light of there being no appeal, would you kindly make a motion to withdraw your appeal pursuant to Connecticut blah blah blah? Since the motion requires a hearing under the statute, the motion can be heard on January 17th, 2010 Administrative Appeals calendar in the court. Assuming the motion is granted, you can then file with a withdrawal in a customary manner. Please note that the revised plan, including notes on the plan and construction details in your engineer's memorandum in response to stormwater issues or part of your application will be needed adhered to in order for the use of the property to be in compliance. This is a letter from our attorney to Mr. Watts. If you intend to occupy the office space in the building rather than to be claimed as home occupation, which is subject to another part of pending litigation, I would urge you to obtain certificate of zoning compliance. This would allow you to withdraw your pending appeal of the ZBA decision, which denied your existing use as being a lawful home occupation. Such a withdrawal would likewise require a motion of withdrawal. There's considerable discussion during the pendency of your application concerning your access to Route 1, although both the ZEO and I advise the Commission that the access is within state jurisdiction. You will need to provide evidence that you have obtained state permit prior to issuance of any certificate of zoning compliance. So
that's a letter to Mr. Watts?
That's a letter to Mr. Watts from our attorney saying that basically everything seems to be in order and resolved and nobody appealed our decision, and we basically are saying through our attorneys that we've resolved the issues between us. And we are no longer, we should resolve our lawsuit, and that is still pending. Okay. And that is from our attorney to Mr. Watts.
Could we have that?
It's not marked confidential, so I could go ahead and release that, I think. And this is still under confidential portion.
Yes.
So was there anything else you wanted? The other attorney's letter that I had from him?
Sure.
Those. The others in
I can make a
minutes.
copy. If you
Yeah,
want.
yeah, that would be great.
No problem.
I have a hard time keeping track of all this
Absolutely.
paperwork anyway. Thank you.
That's a lie.
Feel your pain.
I go through once a year a green garbage bag full of paperwork from that office. It's unreal how much paperwork is generated.
I remember when the computer got popular, they were supposed to put the paper business, paper companies out of business.
And you had these then, the public hearing transcript?
Well, we asked for everything from planning and zoning, so we
do
have two
that.
packages.
It's really, we're just addressing the complaint about these two individuals and when they knew what they knew when they voted on what they voted on. You know, the application itself and the nuts and bolts of it is, it was just so confusing to us.
I appreciate being allowed to clarify things.
You did.
But unfortunately, I still think as an ethics problem, you're still left with the nut of the issue, and that is how does that ethics complaint specifically apply?
Well, we'll let the issue of
Where you go too far one way or the other, of course, I know this from zoning, where somebody comes in and tries to add a long story, the judge will throw it out. If it doesn't apply specifically to the ethics violation, or in our case, zoning regs, we get hammered on that. We get lawsuits on that all the time. Unfortunately, no matter how many times in a meeting I try to advise the commission members, look, you can't simply state, I don't like something. It has to actually be against the regs. Fine, that you are against something. Please, as a commission member, bother to read the regulations and state your argument. Actually citing the regulations. That would be nice. And if you look at those minutes, you'll find that a lot of those deliberations didn't do that at all. Didn't. It's quite sad.
Yeah. Okay. Anybody know how to turn that recorder off now? And